Miss Covington, my next question is to you, as you just mentioned that you don't aware if you work there. When I work at the DPL branch, okay, the reason you mentioned earlier, I was happy. You mentioned that it was a fresh start for me, and that because that I had issues with other colleagues at the East, mainly Barbara and then Kyle. Okay. What I'm seeking to know from you, Mrs. Cottington, when you, let me try to make this shorter. When was the next time that you hear any complaint again after that I moved to the DPL branch?
That would have been in April of 2017.
Okay. And that complaint was initiated by whom?
Yes, that's correct.
By whom the complaint was
By
initiated?
whom? Rachel Fever.
Rachel Fever. And that's around circa April 2017, right?
Correct.
Okay. Was that complaint made in writing, like via email? How was that complaint made?
It was made to the manager.
To the manager of the branch?
Mhm.
And who's that manager?
Megan.
Megan Valeriano. Okay. And you recall you called me in an office. Megan, Nathan was there in that regard. You recall that, right?
I believe so. Yes.
You recall? Okay. Do you recall that I denied those allegations?
Yes.
Okay. And throughout the hearing, I mean, you hear, because you've been sitting in here, everything. With that sexual allegation, it was regarding text, sexually explicit photos, etc., right? In those lines that I sent to Rachel. Is that correct?
I don't recall anything about photos, but yes, there were some personal texts that were sent to her.
And let me be more specific regarding personal text. They are sexual in nature, right?
I does at the April time.
Yeah. Yes, that's where we are with the Rachel first complaint.
Correct. That was more about, I believe it was, hey, let's connect at the gym, or will I see you at the gym type of thing. I don't believe there was anything that was sexual in nature at this April timeframe.
I'm a little bit, I'm not following it. So there was no text that was sexual?
Not that I recall.
Not that I recall.
At the
Do you recall
April.
the testimony? I'm sorry, go ahead.
She had other complaints in September of 2017 that were more sexual
Let's
in
just
nature.
stay with the first one, please. Let's just stay with the first one. Yes or no? So there were texts that I sent that's sexual in nature to her. Is that correct?
She just testified, Mr. Michelle, in April of 2017, there was nothing sexual in nature.
Okay. Thank you, Judge. Mrs. Cottington, as you're sitting through this hearing, you recall Mr. Vinden Braden testimony that there were sexual texts that I was sending? Do you recall that?
I don't recall his specific testimony. No.
You don't recall? Okay. And did you have any type of copy of those texts while you're investigating that? Did you get any copy of the text that I sent to Rachel?
I was not involved in the conversation with Rachel.
Ma'am, if you can please, because I sit and talk to you in that regard of that complaint, I'm just asking you, did you collect any of those texts? That's all, yes or no?
No, I did not have any of those texts.
Okay. Thank you. You also mentioned, I'm going by memory, you mentioned that part of the complaint of Rachel to me, it's including me acting like her boss. Is that right?
That was in September.
Yes. So
Mhm.
my question
Yes.
is that yes? Okay, thank you.
Yes.
Yeah, the date doesn't matter there. And that also, is that an infraction if I act like a boss?
If it's causing an issue with the others within their work environment, yes, it can be an issue.
Okay. You mentioned also that I walk her to her car as part of me harassing her. Is that right?
That's what she had shared in April. Yes.
Okay. You are aware that the bank have a policy when somebody is closing, okay, they should not walk alone to the vehicle. You are aware of that, right?
No, I don't believe there's any written policy that would state that a colleague needs to walk another colleague to their car.
Okay. So it is not a written policy that when you close a bank, the two closers that close at the same time have to walk together. It's not a written policy, but it is some type of a protocol the bank follows on the direction of their immediate managers.
They need to stay at the branch and leave, close the branch together, but how they separate after they have left the branch.
Thank you, Ms.
That's-
Cording. That's exactly what I'm getting to.
Mhm.
It is required. I never see it written, but it is required. That's what I was getting to. Two people have to live together at the same time when they're close. Okay. In your investigation into that matter itself, as it regard to Rachel, you did mention that there was no ground, if you put it, to establish a sexual harassment case against me. Is that correct?
That is correct.
And Mrs. Codington, is there any mention to you, were there any mention to you prior to September, at our September, when we talked, before I get suspended on September 27, actually, at those days, were there any mention to you of my complaint to Megan regarding of the September 27? That's when the application with Mr. Moss, that's the date. Were there any mention to you that I complained to Megan regarding some concerning gesture from Mr. Moss before the shift started with a hat in his hair?
No, I was not aware of that.
What about when we talked then on my suspension date? I believe that could be September 28th. On my suspension, did you recall that I mentioned that also?
No, it's not in my notes.
Okay. And Mrs. Production, that On September 28, when we talk, one of the first things we talk about, actually, the first question you asked me is regarding another complaint of sexual harassment to Rachel. Is that correct?
I don't recall. I believe I followed the outline that I had prepared.
Earlier in your testimony, you mentioned that I make a comment toward Rachel that I can satisfy her sexually. That was part of it. Did you recall now?
Yes, we did have conversation about that
And
with
that
you.
was part, yeah, and that was part of the last, when I get suspended, that was the last conversation we
Yes,
had
that was
when I was
part of
put.
that conversation.
Okay.
Mhm.
Okay. Who initiate that complaint?
Rachel did.
Rachel did? To whom?
Rachel had shared both with two colleagues that she had concerns about comments that you had been making to her.
So it is Christopher Moss, per her own, per the email that is sent, that mentioned that.
Along with Sue.
Okay, that heard it. So, okay. And that, of course, that is after that altercation of 27, correct?
That we were made aware of it, yes.
That's exactly when you were made aware of Rachel again.
That's when I was made aware of it, yes.
Yeah. And it's never Rachel directly that's come either to you or any in writing where we have it, where she does those allegations, right? They never, is that right?
No, she did not bring the concern directly to me.
Yeah. And there's never those complaints in writing also, either via email or.
No.
Okay. And Mrs. Coddington, all the decision you take regarding this whole investigation altogether, it's all based on statement you get from colleagues and managers, correct?
That is correct.
Okay. And the reason is that because you find them to be credible, right?
That is correct.
Okay. And you don't have, throughout all this time, you don't have any other independent type of evidence or proof of any of those allegations from those other colleagues that I was loud, that I was threatening whatsoever. Do you?
Objection, just to form, the use of the word independent.
What kind of evidence are you talking about, Mr. Michel?
Oh, yes, I will clarify then. Any other witnesses from customers or video, audio, any type of other evidence than statement from the colleagues, my colleagues.
It was not identified that any customers were involved, and it would not be appropriate for us to involve customers in that. Our video does not have any audio, and we don't use our video to see what colleague behavior is, and there's no other audio available to us.
Okay. And did you seek any type of surreptitious kind of surveillance, any visit by any type of coming to the branch? Is there any of that?
Did I?
Yeah, yourself or any of the managers that were investigating as part of it?
Well, Nate was at the branch.
So are you saying it was a manager that witness of those happening? Is that is are you saying he's a witness of those allegations?
No.
You getting me? Okay, so he's not. So there's none. There's no managers that ever witness anything like that.
That is correct.
Okay, thank you. And you mentioned throughout the hearing, you mentioned it's me getting frustrated because I'm not getting feedback, because I cannot cash check specifically that you put there. Is there any, on my record, any write-up regarding work performance whatsoever?
No, there is not.
There's not. As a matter of fact, it is only the statement you get from those colleagues after that I file my complaint. That's the only way you're aware of those, right? Any issue regarding me.
Your complaint was filed in February of 2016. So yes, other issues that we dealt with after that time would have been after your complaint.
Yeah, you get me this right. My question to you, Mrs. Coddington, is that this is the only time that you get any type of complaint about me is after that I file my complaint to you. That's the only way you get anything in my regard that I did wrong in general.
That's kind of the nature of my role, is that I deal with performance issues within the work environment. So the only time that I am involved is when there's issues that need to be worked through.
Probably I was not clear, but I will try that one last time here. Any of those issues regarding me, it's only after that I file my complaint to you that you get involved. That's the only way. There's no other time at all that you get a direct complaint from me.
That is correct.
Okay. All right. I do believe, I don't see what, okay. I do believe that's all that I have for you, Mrs. Coddington. I don't see anything that I have here, but I do have a few notes. I will talk with the judge. That's everything that I have, Judge, for her.
All right, Attorney Bullocks, do you have any other questions for Ms. Coddington?
Yeah, Judge, just a few quick questions for redirect. Mrs. Connaughton, just so that the record is clear, because I believe you were cut off at one point when you were explaining this, but is there a requirement, written or otherwise, that when colleagues close a branch, they need to walk to each other's vehicles together?
No, there is no requirement.
Okay. And you testified during cross-examination that Rachel did not bring any concern directly to you, I believe in September of 2017. Is that correct?
That is correct.
Okay. But you did discuss the situation with Rachel, right?
That is, yes, we did.
Okay. So at this point, I want to just show you again exhibit number 28. If you can go to the document that's base stamped at the bottom as R094. All right. And these again are your notes from your conversation with Rachel on 9/28/17. Is that
That is
correct?
correct. Yes,
Okay. And it's correct, as we discussed earlier, that she reported to you that Mr. Michael told her that he could pleasure a woman and he learns what to do and that they should go out on a couple of dates. Is that correct?
that is correct.
Okay. And then regarding the February 2016 internal complaint that Mr. Michael filed with the HR Advisory Center.
Okay.
Is it correct that your testimony earlier was that there were issues that were raised to Mr. Michael's manager in January 2016
That
about
is,
concerns other colleagues had about Mr. Michael?
yes, that is correct.
Okay, so there were concerns about Mr. Michael that pre-existed his February 2016 complaint.
Correct.
Okay. All right. I have no further questions.
Any other questions, Mr. Michelle?
Yes, with the final question that the attorney asked, actually, you mentioned there were prior complaint regarding me prior to the 2016 complaint in my regard. Is that correct?
That is correct.
Is there any record of those?
There's the email that Kyle sent to Nathan Vanden Branden. There's also a written document that Barbara had sent to Nate along. You had an email all pertaining to that incident that happened on January 24th.
Okay, thank you for mentioning Jen. So this is, yeah, for January 24th, but this is basically what that is the same as what I complained to you about on February 5th. That's escalated, right?
Yes, that was included in there.
And that's exactly what we discussed then. That's the same thing we discussed. Yeah?
Mhm.
Okay, all right. So with that being said, what I have you here, one last thing that just get my attention. It was on Exhibit 29, the list of, it's a list of the other white that have get the same pay with me. I believe you have it at Exhibit 29.
Judge, if I may, I can just object this being outside the scope of redirect.
It's fine. You can ask your question. Go ahead, Mr.
Yep,
Michelle.
Yep, I won't be long. One thing I want to know regarding this, Mrs. Cottington, all those universal bankers, white, you just identified earlier, you mentioned I get paid more to some of them. Now, this document does not take into consideration work experience, education background, does it?
Well, that would be taken into consideration when they were offered their compensation.
So some of the white people I get paid more than. I could have more education and more experience.
Possibly.
And also that document, some of the white that have more pay than me, I might have more education and more experience than them too.
I'm not involved in the assigning of wages, so
If you can answer by yes or no, because you did answer for your.
yes, I suppose that could be a
That could
possibility.
be, yeah, that could be a possibility. Yeah, because you testify on it earlier. That's all, Judge. I just have some general objection that I want to outline later, please.
Right. Any other questions, Attorney Bullocks, for the witness?
No,
All
Judge.
right. So I believe that's it for the respondents then. We've addressed all the exhibits that you had moved into evidence as well. So the respondent is resting its case. Mr. Michelle, do you have any rebuttal evidence?
Yes, it's just some general objection that I will mention. I'm going to try as much as I can. I go by memory with this. It's a lot. A lot of the testimony regarding the note, the handwritten note of allegation, I deny all of those statements from Sue, from everybody. I deny all of those. I want the hearing to know that I deny all of those. The same specifically for the allegation of sexual harassment. I deny all of those. I deny all of those for the record. I want the record to know I deny all of those. Never happened. Read up. See if those are my trying to recall one more objection, Judge, that I might have. I know that's what you talk about. I think this is it, Judge. That's all that I can have. Looking through all my notes. Yeah, so I object to all of those as not factual regarding the sexual harassment. It's made up. The same regarding yelling and unprofessional behavior. And that's it for me.
All right, so then it sounds like we have all the testimony then from all the parties and all the witnesses. I don't remember if we talked about doing any kind of post-hearing briefing. Did you want to do a final brief summarizing your arguments?
I'll let Mr. Michelle go. And, just, Mr. Michelle, I apologize. I think I've been pronouncing your name, Mr. Michael. And it's Mr.
Michelle, but I would interrupt you for that. Yeah, I understand. Yeah, yeah, I know. I get that a lot, so I wouldn't interrupt for that.
Okay.
Yes, and Judge, to answer your question, yes, I would like, of course, yes.
Okay. Typically what I have the parties do is just file one brief at the same time. And I usually say like 30 days after the hearing. So what is today? January 21st. So we'd be looking somewhere around like February 21st to do that. Would that work for everybody's schedule, or would you need some additional time?
Yeah, Judge, if we can get another 30 days, what we plan on doing is in all likelihood getting the video, and then maybe even getting it transcribed. And I just
Okay.
don't know how long that's going to take.
So we'd be looking at like March 21st then? Is that what you're saying? Somewhere in there?
I think that's fair.
Okay, let me just bring up my calendar to make sure that's not like on a weekend or something.
Okay.
Yeah, March 21st would be a Monday. If that works for everybody, I can put that as the deadline for the parties to do that. And then I don't think I had our staff send out the recording from the first 2 days of hearing, but I can have her send out today's hearing as well as the previous 2 days to everybody. I don't know if I still haven't figured out how they're exactly doing it. I think they're doing it with just sending everything on a CD, but given that this is 3 days, I'm not sure. It might be multiple CDs. I think they've also tried doing it, and I think you guys might have used this where we have this like file sharing program. They might upload them there and then have you guys just download them.
Okay.
I'm not sure. Do you have a preference one way or the other? Would you prefer a CD, or are you okay with doing the download?
For me, the download, I barely use CDs anymore.
Okay, then I'll see if they can just do a download to, and Attorney Bullocks, looks like you're
Yes.
shaking your head as well.
Same here, yeah.
Okay, I'll see if they can do a download rather than sending a CD. If there are any issues, reach out to me. I'll probably get the recording for today's hearing later today so I can upload it. So everything should be available to our staff on Monday. I'll follow up with her Monday and say, get this out to everybody. And she's usually pretty good at getting it out within a day or two. But if it gets to be, like a week or so, next week, Friday, you still haven't received it or something, follow up with me just to let me know and I can make sure, because I want to have you guys have it so you have enough time to do your briefs. And like you said, Attorney Bullocks, if you do a transcript, sometimes that takes a little bit of time to get a court reporter to transcribe everything. So if you don't have it in about a week or so, just follow up with me and I'll see what's going on with that.
Okay. And Judge, if I can ask you in terms of the briefing, kind of schedule and plan. So the parties file dual, I guess, opening briefs, and then is there a response to
Did
those?
you want to have a response as well? Like, how long would you need to do a response?
I don't know, maybe 21 days or something like that.
Okay.
I think
So the initial briefs due March 21st, and then having a response due, I guess that would be like around April 11th. Would that work for everybody?
works for me.
Okay. I want to get a good grasp of this, Judge. on March 21st,
Mm-hmm.
that's the date we will submit a brief of the
Right.
hearing.
Right.
Then there is a response to it.
Right. So what the response would be once you get Attorney Bullock's brief on March 21st, if there's anything you want to object to or respond to in his brief, you would have until April 11th to file that with me.
Okay. Thank you for that
And,
clarification.
and him the same thing. So once he gets your brief on March 21st, what he's going to do is look it over. And if there's anything he wants to address or say, you know, you should disregard this, or, you know, I don't agree with that. That's kind of what the reply brief is for both of you, is looking at what the person submitted on the 21st. And then by March 11th, providing your responses to that. Does that make sense?
April 11th, right?
April 11th. Yeah. Yeah. So
the
March
date.
21st and then April 11th.
Thank you. And I made it too with my coughing. I'm coming down with something, yeah, but it did. Okay, March 21st. Okay, got it.
And I'll send an email out to you just confirming those dates as well, because I know we're getting towards the end of the day, and I'll just send an email so you have that for your notes as well. Was there anything else, Attorney Bullocks, you wanted to address today?
No, other than just to confirm that, like other, items that we file this via email with you.
Yeah, you can do that. That's fine.
Okay.
It's
all right.
probably the easiest way of getting things to me is by email. It's probably the fastest way of getting it. And it's easier because then you can just copy the other side on the email as well. And then I can see that they got it as well.
Okay.
So email is good.
I'm gonna make one last clarification, Judge.
Sure.
Now, the brief,
Mm-hmm.
we can submit it via email. That's what you mentioned, right?
Yes. Yep.
Okay. Good.
Yeah,
Thank you.
and you don't have to resubmit like the exhibits or anything like that. I know sometimes parties do that. They'll because I have all the exhibits, so you can just reference the exhibit. You don't have to send additional copies of the exhibit. I wanted to clarify that as well.
Okay. Thank
So
you.
it can just be your written argument. In essence is what I'm saying.
Okay.
Okay.
All right. Any other questions, Mr. Michelle?
None. No.
All right. Anything else, Attorney Bullocks?
No, that is it, Judge. Thank you very
All
much.
right. Well, thank you both for concluding everything today. If you do have questions after today, feel free to reach out to me. Otherwise, once I get your briefs on April 11th, the final brief, that'll start the deadline for me to get my decision out. So we try to get them out within 3 months of us closing the record. So you get your final briefs to me April 11th. That means I would have somewhere until July at the latest to try to get my decision out to everybody then.
Okay.
All right, as long as there's nothing else, I will let everybody go. Thank you, Ms. Coddington, for your testimony today, and thank you, the rest of you, for participating today, as well as the previous 2 days as well. Take care, and like I said, if you have any questions for me after today, just follow up, and I'll do my best to answer them.
Great. Wonderful. Thank you, Judge.
All right,
Great.
thank you, everybody. Have a good evening.
Let's take care. Bye-bye.
Bye.
Bye.